U.S. Supreme Court taking gun ban challenges from Illinois and from Maryland and putting them into conference for May 16th, where they'll talk about them behind closed doors and what could possibly happen. It's a great question, something I don't think that we know yet. There's a lot of speculation out there, but is it indeed something that's going to change the trajectory of gun laws in the United States? Welcome back, Bishop on Air. Thanks for hanging out with me each and every weekday morning. Really do appreciate you guys being here. And I wanted to share with you some of what's going on here and how we've got the ongoing gun ban litigation in the state of Illinois, where it's right now in the Southern District courts. And that has the state defending the ban on more than 170 semi-automatic firearms. And clearly that's something that, a lot of Illinoisans are frustrated with. So yesterday we talked about some of the latest filings and the U.S. Supreme Court when it comes to gun ban litigation, where you had preliminary actions. And I want people to make sure they understand that the preliminary actions that have happened so far have really just been on whether or not there should be temporary action blocking the law from being implemented before you actually have, some penalties. And while the case is being dealt with, somebody yesterday commented, what does it mean to advance on the merits? Well, preliminary actions, you ask for a temporary hold on the bill or on the law while the case is dealt with through evidence being laid out and a judge weighing the balance and determining on the merits which way this ultimately will go. So all those preliminary actions already went to the 7th Circuit U.S. Court of Appeals from a Southern District case and Northern District cases, differing outcomes there. 7th Circuit rules that the state had a likelihood of advancing on the merits. And then you had the question on the merits go back to the Southern District of Illinois. But at the same time, you had the preliminary actions being taken to the U.S. Supreme Court. And that's where you had these various cases. And as we talked about yesterday, it had not yet happened. But looking at the cases here, you've got the Barnett v. Raoul case. Again, this is from the Southern District of Illinois, where you have the plaintiffs alleging that the gun ban violates the Second Amendment, right to keep and bear arms. The state came back and said, no, these are weapons of war, they're military grade, and they should be banned. So clearly, you've got the question there still being dealt with in the Southern District Court. But back to the U.S. Supreme Court, February 12th, after the 7th Circuit Court of Appeals issued its mandate, you had petitions for writ of cert, and that's a request for the U.S. Supreme Court to hear this case. But again, it's important, this case is only on a preliminary basis. It is not on the merits. So this was the case with several other cases. So this is just the Barnett case in particular. We'll look at this from the docket of the U.S. Supreme Court. Yesterday, they ultimately distributed it to conference. All right, so what does that mean? The U.S. Supreme Court has open arguments about cases that they agree to take, and you see those headlines all the time. But not a ton of headlines about sending stuff to conference. We had a similar case with, I believe it was the Calkins case, where they sent that to conference. I think even the Naperville case, they sent that to conference. But the Supreme Court rejected taking those cases. This one seems a bit different. And I talked with Alan Gottlieb a bit yesterday, and he said that this really does signify that they're going to take the case. And Alan Gottlieb from the Second Amendment Foundation, he said that they are going to take the case, he believes, and they're going to consolidate them because there are 4 cases from Illinois that I saw that were sent to conference where they're going to talk about it behind closed doors and determine whether they're going to take the cases. But they also sent the Bianchi case out of Maryland, challenging Maryland's gun ban. So they sent that to conference. So that seems to signify to some that this could be them taking this and possibly deliberating on whether they approve to take the cases and then consolidate them, which would address nationwide whether or not states can ban semi-automatic firearms. Costas Morris posted on X that some different outcomes here, and I think this is good for us to review. He says that you've got the Illinois cases being sent to conference for May 16th. and we could get a decision then. But they could also relist a couple of things. So from here, he says a number of outcomes are possible. The Supreme Court of the United States could grant cert in full and hear the case in the next term. If that happens, the parties will submit more complete briefs on the merits, and oral arguments will be likely heard sometime in the fall. Our upcoming trial before Judge McGlynn would likely get stayed. And I think that that's interesting because you have the case in the Southern District of Illinois, where Judge Stephen McGlynn is advancing on the merits, and even questions of, are they going to have a trial come July? So when I talked with Alan Gottlieb yesterday, he said we could find out by the end of this month if indeed they are going to take the cases and possibly even determine when they would hear the challenge. And if that's the case, they take the cases, whether they consolidate or go individually, that could mean the Southern District of Illinois case is stayed. Back to what Costas Morris has to say. Number 2, he says the court could also opt to issue summary reversal, which would reverse the Seventh Circuit without further argument and briefing. Such summary reversals are usually accompanied by a per curiam opinion explaining the action. I see this as least likely, he says. They won't decide an issue this big with a per curiam. I could be wrong, he says. Number 3, he says another alternative is the court to grant cert, vacate the Seventh Circuit's ruling, and remand it back to the court for further proceedings. This would be a scenario in which the Supreme Court's not quite ready to hear the case, but does want to give the Seventh Circuit guidance on how to correct errors in its legal analysis. Something similar could happen in the event that the pending ruling in Rahimi, which is a case dealing with individuals who are, prohibited from having firearms through various things like protective orders or whatnot. But the Rahimi changes the Second Amendment analysis in a way relevant to the Bevis ruling. Number 4, Costas says, finally, there's always the possibility the court opts to deny review entirely for the time being, preferring to hear the case following a final judgment, like something out of the Southern District of Illinois court. If so, we go to trial and climb the ladder all over again. If that happens, the real test will be Duncan, which is on final judgment, so no excuses. So interesting. Again, some of the analysis here from Costas Morris on X to the U.S. Supreme Court moving cases to conference. So again, next couple of weeks are going to be pretty big. You've got the Southern District case where the deadline coming up in a couple of weeks for the litigants to file who their experts are with the eye of possibly having a trial in July. But now you've got the U.S. Supreme Court moving all these gun ban challenges into conference. What does that spell out? We'll do what we can to keep you updated every morning here with Bishop on Air. Be sure to like, subscribe, and hit that notification bell. Appreciate you guys being here each and every weekday morning with Bishop on Air.